Who is going to have power of attorney, right? Not only over the financial side, but your healthcare side. Who do you trust implicitly? I've seen tragic situations where the wrong name was listed as power of attorney and pushed aside the wishes of that closer relative. Tragic, tragic, tragic. Hey folks, Colin Richards here, president and founder of Lord & Richards, and in this particular segment of the Lord & Richards Show, we are continuing our discussion of the vital necessity of a written estate plan. And in our last segment, I described some of the reasons why you need to get ahead of the curve, why you need an estate plan, including potential changes in the law. And those changes also could affect something I didn't describe in that segment, which is something we really rely on right now, the step up in basis upon death. For example, if you owned stock in your family and you decided to pass that on, in the majority of circumstances, your heirs can receive that and not pay the gains on the appreciation and the value of that stock. Same thing for your home. And so if that were eliminated, that could create a tremendous burden on many people. And there are proposals to try to do that, to literally eliminate the step up in basis. So the other reason why I want you to get a little bit more proactive is I don't want you to depend solely on wills. Again, some of you have wills that you've downloaded from somewhere or got free, but wills in and of themselves are just a starting point. They have certain weaknesses. For example, you can't guarantee who receives your property. Okay, in a will. You said, but it's right there. It says it. Yeah, but wills are contestable. Right? And you might have had a certain set of desires. Maybe, Johnny or Susie, if you had a daughter and a son, Johnny went to explore his career and become a Wall Street stockbroker and made millions. And Susie stayed home to take care of mom. And when mom passed, she wanted to make sure Susie got more. But Johnny comes along later and contests that. And so we're going to have to take some extra steps if we want to guarantee that our property goes to the people we want it to in the proportions we want to. In addition, this goes typically through a $3,500 to $5,000 process we call probate. So that just gets pulled right out of your legacy and paid out to lawyers, etc. Also, wills are public record, right? So they don't ensure you the privacy that you may want or need, especially if you're not going to be exactly equal in the distribution of your assets. You limit the ability to control your assets upon death. Maybe you want to leave to the kids and grandkids, but not the wife. Maybe the wife brought in, you're in a blended marriage situation and you want to be able to direct certain assets that way. You want to keep it on one side or the other. Well, then you're going to need to set up special other types of documents such as trusts. I'm aware of a client who set up a trust where the grandkids had to be a full-time student or employed in order to receive funds. So being able to put special constraints. In addition, a will is bypassed by assets that already have a beneficiary attached to them, such as your IRAs or your accounts that are set up jointly or transfer on death or life insurance. So there's whole classes of assets that can bypass your will, requiring you to constantly update all those other things. Whereas with a trust as owner, you can simply update one document. And so I'm going to be talking about trusts a little bit more in a few moments, but I just want to say that wills by themselves, a lot of times people, just to save a couple bucks, do not complete their estate plan. And one of the pieces that they may leave out because they have a will is a trust. Okay, so be very careful. The second matter, in addition to weaknesses of wills, is the matter of health care. Okay, many people fail to get the right names on the right documents before someone special passes away. In addition to the normal legal documents, you've got to get things set up so when someone gets sick, somebody has control over accounts and so forth. Okay, this is often forgotten. So you need to have that in place. Who is going to have power of attorney, right? Not only over the financial side, but your healthcare side. Who do you trust implicitly? I've seen tragic situations where the wrong name was listed as power of attorney. People stepped in as power of attorney and pushed aside the wishes of that closer relative. Maybe it was a spouse who came along later in life. Tragic, tragic, tragic. Is it possible to protect assets so they're not consumed by the nursing home and hospitals? You remember, I said this is the default. If you don't get ahead of things with your estate planning, everything goes to the government and hospitals and nursing homes, okay? Let's not do that. Let's prefer to leave those assets to a special cause, a charity, your church, a missionary, or your family, the people that love and care for you. There is one special kind of trust that specifically targets avoiding having to leave all your money to the nursing home. You know that you have to pay out of pocket for the nursing home after the first 90 days covered by Medicare. You say, well, what about Medicaid? Doesn't that jump in? No, not until you've pretty much wiped out everything you plan to leave behind. So we've given a name to this. It's just a trust, but to highlight the purpose of it, it's called a Medicaid Asset Protection Trust. Effectively, what you're doing is you're going to gift your assets to the trust, taking them out of the assets that have to be reported for Medicaid. Now, first of all, Medicaid, if your family or you applies to try to receive some assistance from Medicaid, they're going to look at all your assets, and you're not going to get anything until you're pretty much poor, because that's what Medicaid is for. It's health insurance for the poor, and it's your only hope instead of paying out of pocket if you want to cover your long-term care or chronic illness. There's a 5-year look back on those assets in the trust. So you need to get ahead of the curve and do this sooner rather than later, because what if you need care next year or the year following? Okay, you've got to start that clock 5 years backwards. What assets got moved? And they're not going to give you anything until you pay out of pocket. Now, you might be afraid of transferring those assets because you said, well, Colin, you said gift to the trust. Does that mean I lose all control? Well, effectively, yes, but you have a trustee that you trust implicitly who can still use these funds for your health, education, maintenance, and support. We call those HEMS, H-E-M-S, and that means they can help pay for your other bills out of the trust, protecting the assets, though, so they don't have to be reported and you can qualify more easily for Medicare. So 2 big issues that really require us to take, the vast majority of us, to take another step forward beyond just a will, beyond just letting things follow their course. Number 1, wills have weaknesses. And number 2, you need to get ahead of the game with healthcare, either with trusts, powers of attorney, or combinations thereof. I often tell people these are the critical documents to make sure your wishes are honored and your legacy isn't wiped out by the government and nursing homes. Folks, it's time to pick up the phone and have a conversation, right? I want you to talk to us. I want you to tell us what's critical and important, and let us help build together with you a comprehensive written plan to make sure not only are you financially independent, but when you pass away, your estate plan protects those assets to leave them for the causes and people that you love. It simply starts with a phone call.